still got people joining, but in the interest of time and being respectful of people's time, I wanted to finish on time. I'm going to start. So good morning all. Nice to see you. Thank you for joining. My name's Dawn H. Jones. I'm Managing Director of Hope Place HR, and we help organisations sort of like, we formulate practical solutions to frustrating and often challenging problems. So I'm just going to do a bit of an intro, a context, and then we are going to get into our session. So as I said, my name is Dawn H. Jones. I'm Managing Director of Hope Place HR, and I'm joined by Sejal Raja. Sejal, do you want to give a wave? And Sejal, a partner and Head of Employment Law at Radcliffes, Brasseur. And we're here to discuss the outcome of the government consultation on sexual harassment in the workplace. So what I have done for you guys, if you haven't read it in the background reading, I've put the link in the chat, so you can always go away and do the background reading when you have a moment. So ACAS defines sexual harassment as unwanted behaviour of a sexual nature. And the law, that is the Equality Act 2010, protects employees and workers, as well as contractors, self-employed and job applicants. So before we actually go into the question and answers with Sejal, I just want to set the contents for this discussion. So around sexual harassment, that is. So in 2006, Tarana Burke, who's a survivor and activist, founded the Me Too movement. And it was to respond to sexual violence. And the Me Too movement, what it did was it helped shift cultural and societal views on sexual harassment. Now, in 2017, the Me Too hashtag went viral after an actress called Alyssa Milano posted on Twitter, "If you've been sexually harassed or assaulted, write Me Too and act," as reply to a tweet. Now, that tweet, according to the NBC website, that is, generated thousands of responses from Lady Gaga, for example, from celebrities such as Lady Gaga, Viola Davis, Javier Munez, and they were amongst the celebrities who responded. But there were many people, many women who were not household names, and they also spoke out. And there were nurses, teachers, engineers, florists, waitress students, mothers, daughters, wives, and some shared for the first time that they were victims of rape. Others talked about fending off aggressive co-workers and losing their jobs. And as we know in the media, high-profile individuals have faced reputational damage and or criminal charges following allegations of sexual harassment. Now, the UK has also been affected by the Me Too movement. And I learned this when I was researching this topic, but earlier this year, maybe last year, but last year rather, 10,000 students and former students shared their experience on sexual harassment that they received from their peers on a website called Everyone's Invited. And from a nursing perspective, a Nursing Times workforce features highlighted nurses' experiences from the 70s to the present regarding sexual harassment from patients, visitors, and colleagues. For example, one nurse said some degree of sexual harassment was almost expected in the workplace, and that's from patients and staff. And she also said comments, touching, groping, cornering, all the way through to assault and rape. Now, a few nurses reported their allegations, but sadly, they were not taken seriously. And some nurses were not even aware that they were suffering from sexual harassment. And a retired nurse is currently campaigning for more robust protections in the workplace. And one student nurse suggested patients sign a disclaimer that sexual harassment would not be tolerated. Now, according to the article in The Guardian, teachers face threats of rape and verbal abuse from pupils. You know, these are children, teenagers. And the sexual harassment includes, and pardon my language, being called a slag and slut. And in addition, an investigative report by the Telegraph of sexual impropriety has implicated 2 drama students. And according to that article, investigations are still ongoing. So sexual harassment is an issue that's undoubtedly infiltrated society. And there are examples of sexual harassment in most now, if not all, parts of the workforce. And as a result, some employees do not feel safe in their workplace or working online from home. And I can't remember who I was speaking to when I was discussing this webinar, but someone was telling me that actually sexual harassment has increased whilst people have been working online from home. So that's the context to the background to our discussion today. And so I'm now going to move on to the government consultation. So between the 11th of July and 2nd of October 2019, the government consulted on sexual harassment in the workplace, and the consultation received responses from over 130 charities and employers and over 4,000 people. Now, following the consultation, and I've put the link in the chat for you, the government plans to do three things. So firstly, they plan to introduce a new duty requiring employers to prevent sexual harassment in the workplace as soon as parliamentary time allows. Number two, they plan to introduce workplace protections against third-party harassment, again, when parliamentary time allows. And lastly, they will continue to engage with stakeholders, particularly regarding extending the time limit for bringing Equality Act based claims from 3 months to 6 months. So that's really the background between a very brief whistle-stop tour around the Me Too movement. As a result of what's happening in the UK, some of the disgraceful behaviour that's happening in workplaces. I think the behaviour between students and students and pupils was the one that shocked me the most. And then we talked about government consultation. So what we're now going to move into is I've got some questions for Sejal, and then once we've done that question and answer session, we are going to open up the chat, and then or you can decide to unmute yourself and ask questions. Okay, ready, Sejal?
Yeah, far away.
So first question. Currently, employers have to take reasonable steps to prevent sexual harassment. Would you please explain what this means in practical terms?
Okay, so Dawn, as you've already explained, sexual harassment is protected under the Equality Act, and specifically it prevents employees being subjected to unwanted conduct or conduct of a sexual nature, and also it must have the purpose or effect of violating an employee's dignity or creating an intimidating, hostile, degrading and humiliating and offensive environment for employees. So that's what sexual harassment means in accordance with the legislation. In terms of reasonable steps, an employer can argue that if there is sexual harassment in the workplace, they can argue that they undertook lots of reasonable steps to prevent that harassment taking place. So what are those reasonable steps? Well, the first and foremost is having an equal opportunities diversity policy. And since the Me Too movement, I recommend to all my clients to have a specific harassment policy. And whilst the Me Too movement sort of brought in for the sexual harassment nature, I think it should include all forms of harassment, racial harassment, disability, all forms of harassment. I think it shouldn't be tolerated in the workplace. So as a minimum, have an equal opportunities policy that references harassment, but I've been recommending to clients to have a separate harassment policy. So that's the first thing you should do. You shouldn't stop there though. The second point is to make sure that your staff or all staff are trained on that policy. It's all very well having a lovely drafted policy by lawyers and HR consultants, but you need to make sure that your employees are aware of it, and particularly managers are aware of it, to educate staff and know what's tolerated, what's not tolerated, and that we have a zero tolerance to harassment in the workplace. So that's the second thing, that's really, really important. And the third is monitoring. So you continue to monitor policy, keep it up to date, and make sure that you listen to staff, listen to employees to see whether there are any issues that are bubbling and you can take action immediately. If concerns are made, then you should investigate them and deal with them appropriately. Having a complaint being brought and just brushing it under the carpet is likely to lead to allegations being founded and the employer being liable. So those are the four main steps: having a policy, training on that policy, monitoring, and dealing with any allegations that come into are brought about in the workplace. So that's the sort of reasonable steps that we currently should have in place to deal with sexual harassment in the workplace.
Thank you. What is the difference between taking reasonable steps and the proposed preventative duty to prevent harassment?
Okay, so currently we have the reasonable steps, which is the 4 things that I've mentioned.
Yeah.
And currently an employer is only liable if an allegation of harassment is made and a tribunal finds that the employee has been subjected to harassment. What the government is proposing when it gets around to making this legislation, which it should do, I think it's really important, and it's annoying that it hasn't done it yet. It's got other things like parties and all of that to sort out, but there we go. What it's suggesting is that an employee could bring a claim for an organisation failing to implement or having a policy or training. So let's say you have an employee, the company has adopted a equal opportunities policy, but there's no training on it. No form of harassment's been made or allegations been made. What the government is proposing, that the employee can then report the matter. It's proposing to report it to the Equality and Human Rights Commission to say that this organisation hasn't taken reasonable steps. So the liability starts then, rather than having any harassment allegations being made. So that's a big thing for employers. So that's where the difference arises.
So in that instance, there's no specific claim of sexual harassment, but
exactly.
The fact that the employer is not fulfilling their duty,
yeah.
What would be the potential outcome? What are the implications for that employer?
Well, we don't know yet, but I would imagine that there might be, they're talking about having similar compensation elements as under 2P. So under 2P, where you fail to comply with your obligation to consult, an employer is liable for 3 months' pay for each employee.
Wow.
So they're talking about those sorts of measures. I'm sure it'll be defined once we get the legislation on it, but that's the type of sanction that's being imposed. And also, I think there may be recommendations as well. I think the Equality and Human Rights Commission may well also include recommendations for an organisation to comply with introducing policies and having training in place.
And potentially being monitored until they reach a certain standard. Being
monitored as well. And remember that, you know, like the national minimum wage, where employees are breaching national minimum wage, they're named and shamed. There could be a risk that employers might be named and shamed in this situation as well. I mean, it's all going to be in the detail and what the government introduces, but those are the types of things that are being talked about.
Yeah. Okay. So those are the type of things to be mindful about.
Yeah. Yeah. Absolutely.
Thank you. The government plans to introduce workplace protections against third-party harassment. Right? What are the specific protections? Okay.
So this is really difficult for employers because this arises, a third-party harassment claims arises where you have a client or a contractor who then harasses one of your employees, and an employer doesn't have control over the client or the contractor.
Yeah.
And then what the government is proposing is, well, the employer should be responsible for that, which is really difficult. And there's been lots of pushback by organisations saying, well, we accept that this is serious, but it's difficult to do. So I think what the government is going to propose is have the reasonable steps, processes in place for third parties. So things like making sure contractors and clients are aware of an organisation's zero tolerance policy to harassment, having things in a contractual documentation between the clients and third parties, setting out that if there are any allegations of harassment, then the contract will be terminated. Those sorts of things I think will be talked about. Using your example, Dawn, about the teacher and the student, because that is a third-party harassment, really. That would be a third-party harassment claim. So in that situation, what the school should be doing is educating its students and saying that we have zero tolerance policy within the school environment. Any pupils that are accused or undertake any form of harassment, will be suspended, expelled, etc. So it's those sorts of things that can be done in that environment. It's going to be it's going to be dependent on different environments, different sectors as to how to implement it. But those are the types of things that I think will be needed.
Can you ever envisage a scenario where, you know, the school does all that, but in addition to that, parents could be liable for their children's actions?
Yeah, they could be. Yeah, they could be in a civil claim, because the individual, the teacher personally could bring a claim against the pupil, and then ultimately their parents if they're a minor.
Okay, so the school and potentially the parents.
Yes, yeah.
Thank you.
It's all evolving, and it's all interesting stuff. And I hope the government do something about it soon, because I think it's really, really important to have these processes in place and make it mandatory. Yeah,
but the processes have to be backed with meaningful action.
Absolutely, yeah. And that's why I think the government is setting the mandatory reasonable steps to make sure that not only do you have the policy, you have the meaningful follow-up with the training and educating your staff about what constitutes harassment, why it's not tolerated, and the sanctions that will be imposed.
And it then makes sense that that employer would need to keep training records, so that they're able to demonstrate, you know, the extent to which they've taken to comply with the.
Yeah, absolutely. There was a recent case last year, and I will try and get the link. I did a briefing on it, but what we'll do after this session, I'll send it to Dawn and she can circulate it. But it was the case of LA, UK and Gallen. And in this case, the employee brought claims of sexual harassment against an individual and their employer. And the employer said, well, actually, we've taken all reasonable steps, so we shouldn't be liable for the harassment. So they tried to use that defence in the tribunal. And they brought this wonderful policy that they drafted, and also training records to show that their managers were trained on this policy. So basically, they did what they could. So it's not their fault. It's the employee who was subjected to, who was the who harassed the individual is liable. But what the tribunal said in that case was, well, actually, you've done this training, but this training is outdated. It was 5 years ago, so it's stale. So it's really important that not only do you have proper training, but that's continued and monitored, and it's done regularly.
So could you ever, I mean, that being the case and the potential risk, it would then, what I'm hearing is this could form part of the mandatory training, the regular annual, you know, training that all employees, much like nurses have to have lifting and training or something. Fit in with that?
Absolutely. And one of the questions I ask my witnesses when I'm dealing with tribunal cases, when there's allegations of discrimination or harassment, the first thing I ask them is, have you had equal opportunities training? And in all organisations, and it's the NHS and larger organisations usually have them in place, but not all of them do. And you know, if you're a witness in a claim, the tribunal will often ask that question if it's not already in your statement.
Now, you may already have answered this, but I'm going to ask it anyway and let me know. What proactive steps can an employers take to comply with a new duty beyond policy changes? So that's the training.
Yeah, so you've got your policy, but I think it's training and keeping training regular.
Okay.
I think it's monitoring to make sure that policy is monitored. And actually, what I think is a good idea is maybe having a survey to employees to see how they're getting on in the workplace. And do it annually. Just say if there are any concerns, just just so that you know how the land lies. And that's quite important, because if you do that with a view to seeing that there aren't any problems, you can try and tease out if there are any issues going on. And I think a tribunal will see that actually you're doing something proactively to try and ensure that the environment that people work in is a good environment, it's a safe environment.
So perhaps when people are working with staff survey providers, for example, that they ask for or request a specific section on questions around sexual harassment and an opportunity to ask about harassment?
Yeah, harassment and any form of harassment or any form of treatment that they've been subjected to.
Yeah.
So that we can capture all of those sorts of issues that come out in that in that survey.
Yeah. Okay. Thank you. The government's looking closely at extending the time limit for bringing equality-based claims from 3 months to 6 months. What are the potential implications for employers?
Okay, so currently, before you can bring a claim, you've got to go through ACAS conciliation, and you've got to start ACAS conciliation before the 3 months from the detriment or the act of discrimination or the act of harassment. So if you're involved in an internal process to try and resolve this, it doesn't give you much time to resolve it internally. So that would be helpful, having the extension of time. So I think that's where it is really helpful. The downside is that it extends the process. So if you've already exhausted the internal process and you've decided enough's enough, 6 months is, you've got until 6 months to bring a claim. Well, you've got 6 months until you start the ACAS conciliation proceedings, which then extends the time to bring a claim. And then with the backlog that we've got in the employment tribunals, you may not get your case heard for another 2 years. So whilst I think it's a good thing to try and resolve internal process, it might delay the whole external process longer. And what you would need to do also is make sure that you keep records of training and any investigations for a longer period of time, and make sure that you amend your data protection policies which deal with retention of documents so that you can keep them for a longer period of time.
And also, I think an important point to bear in mind is, extending this also means a potential impact on people's mental health, and they make the decision whether or not they can actually manage that, sustain it, whatever it may be, but it's going on for a longer period of time.
Absolutely.
Thank you. Okay, 2 more questions. And are the proposed changes an opportunity for employers to review their approach to all forms of harassment?
Yeah, no, absolutely. As I alluded to earlier, I think it's really important not just to focus on sexual harassment, but all forms of harassment, because I think any form of harassment in the workplace is not acceptable and should not be tolerated.
Thank you. And last question, what would you say to an employer who has concerns about the forthcoming changes?
Well, I don't think they should be concerned, because basically what all they're doing is just making sure that the processes that you should have in place are in place. So it shouldn't be too much of an issue. I think where employees may fall foul is the training requirements, which I think is really important. I think most organisations will have some form of policy in place, but I think it's managing the training and making sure that's done regularly. I think that's going to be the issue. And if they've got the resource to do that, because that is, that they may not have the resource to do that, but that's something I think might be an issue for some employers. Okay,
thanks, Sejal. We're now going to open the floor to questions, and we've got one from Juliana, and Juliana's asking, is there a minimum age regarding accusations / actions against perpetrators of sexual harassment?
I don't know. I would say I don't think there should be a minimum wage, really. I just think you look at sort of what their capacity is.
Okay. Yeah.
So I don't think there can be. I mean, I guess it depends on what their understanding is of the issues.
Yeah. And that leads us on to a question from Jen from Amaze Associates. What about sexual harassment that involves adults with learning difficulties?
That's really hard. That's really difficult. And it's a good question, because again, you're going to have to look at capacity and whether they do have capacity and knowledge as to what they're doing. I was involved in a tribunal case where a patient with dementia was making horrible racist remarks to a nurse, and the nurse found it offensive, understandably so, and said that the trust that she worked at should have protected her more. But the trust said, what can we do? Because this individual has dementia, she hasn't got capacity, she doesn't know what she's doing. And, all we could do was support the nurse and, advise her that she could work elsewhere or go to a different ward. But it's so hard when you have individuals who don't have capacity and don't understand what they're doing.
So in that instance where an employer is arguing that our patient or our client doesn't have capacity, from an employer's perspective, how would they mitigate that risk? Because they still have a duty of care to their employee.
Yeah, so it's moving that employee to another role or another set of patients. So moving them from the dementia ward to another ward, or making sure they're assigned to a different client, and dealing with it on that basis. Yeah.
But that wouldn't necessarily negate if another member of staff came in and experienced the same issues.
Yeah. So again, you would be able to, I think, so basically, if, let's say, the service user was targeting females because of the sexual harassment, you would have a male nurse appointed and looking after that person.
Ah, okay.
Yeah.
Yeah. Thank you. How often would you suggest that the training takes place?
I would do 2 to 3 years.
2 to 3 years. Okay.
And also, when you're doing the training, I know some organisations use electronic form of training.
Yeah.
And so, which is an easy way to make sure that the mandatory training's done. Before that's implemented, I would just make sure that it's looked at and you view it properly, just to make sure it covers everything. And also, I know it's hard, but just making sure that staff are actually taking it into account, because some of this online training, people don't take it seriously and they just said, look, it's mandatory time, I'm just going to tick, 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 and I've done it.
Yeah.
So that's just something you just need to be aware of and be mindful of.
Okay, thank you. Does mandatory training adequately address sexual harassment? I'm not sure that existing training has enough of a focus on this.
Yeah, and I think we just covered that, because I think you've got to look at the content of the training that you're putting forward. I always think that face-to-face training is so much better. Yeah. Because you can just highlight exactly what the issues are, what the consequences are, and know that people are listening to you and taking it on board. I mean, when I do training, the first thing I say is put a figure of how much somebody could be liable for, and the reputational damage, not against just the employer, but the individual who's subjected the employee to harassment. That is huge, the reputational issue.
Yeah. So can we just talk about that a bit? Because sometimes people think employment tribunals and there is that cost monetarily, but I always think that there's that emotional cost that one of my colleagues called it the emotional tax. There's an emotional tax to be paid. So if it's a sexual harassment claim, it would be a discrimination-based claim. So can you just give some ideas of the potential financial cost, and we'll go on to reputational costs afterwards?
Yeah, okay. So when you bring a claim in the employment tribunal and you're successful, and the tribunal can award losses, and there's 2 types of losses. The first is a compensatory award. So if you've lost your job because of the harassment or discrimination, it's for the period that you're out of work. So if, because of the treatment you've been subjected to, you've suffered a mental breakdown and you've lost your confidence, which means you can't work again, that loss could be significant, and it could be millions. Yeah. But if you've lost your job and you found another job, then it's the period that you're out of work. So that's sort of how the compensation bit works. You then have an element of injury to feelings, and that's based on the type of harassment you've been subjected to, the length of time, and the seriousness of it. And this is injury to feelings, and there's a band called the Vento bands, and you've got a low band, a middle band, and a high band. So it ranges from £900 to £40,000. Yeah. And that's not based on when you find another job, etc. That's hurt feelings. Yeah. And remember that an employee who's been subjected to harassment, not only can she bring a claim against the employer, she can bring a claim against the perpetrator as well. Yeah.
And in my recent training, I've been highlighting around, people, there's this suggestion, we're talking about sexual harassment in this context, but often when I do training on microaggression and gaslighting, which can be forms of bullying, harassment and discrimination based on sex, I always say to people there is a cost, because people genuinely believe there's not a cost. And I use the Mr. Richard Hastings versus King's College Hospital to illustrate this point. It was a race-based claim, but he actually was awarded 40,000, which is the higher level, higher end of the band. I think in total he was awarded $1 million.
Yeah.
So, but how much would it cost? How much would it cost for an employer to defend a discrimination-based claim?
So it depends on the length of the hearing, but it could be anything between £20,000 to £100,000.
Yeah, so significant. And in terms of the reputational damage now?
Oh, I mean, I don't think you can put any value on that, because if you've got a finding of harassment in the workplace, tribunal judgments are online now.
Yes.
Anyone can see them. Anyone can see them, unless you get an anonymity order, which you may not do. The person who's been subjected to the harassment may get an anonymity order, but the employer won't, and the perpetrator may not get one either. So it's out in the public domain for everybody to see, and that could be a huge issue reputationally, not just in terms of new business, but in terms of recruiting staff and maintaining staff. So that is huge, and also the management time in dealing with a claim also is significant, because you're going to have managers taken out of their day job to deal with giving witness statements and giving evidence in tribunal. So it is big. It really is, and the impact is huge.
Yeah, I've been reading a few tribunal judgments recently, and I've been reading them from the perspective of what the tribunal is actually saying about the actions of the managers, and the way they write it is always very polite.
Yeah.
But they don't hold back at all when they're talking about, especially poor conduct.
Yeah.
So from that perspective, I agree, it's always out there in the public domain.
Yeah.
So I've got a question from Jen, and she said, with respect to contractors, is the government thinking of including this, I'm assuming, Jen, these new requirements in the tender procurement process?
Yeah, that's what I meant, because I think what Sejal mentioned before, when you're contracting with a contractor as an employer, then it's enshrined within that contract. But to me, if there's an earlier stage the government could think about, is ensuring that's enshrined in tender processes, straight up, rather, as well as the employee ensuring, if once they've actually chosen the preferred supplier, they can enshrine in the contract.
Yeah, and I think that's a really good point, and I think that's something that organisations can do when contracting with third parties, is have it in documentary form right at the outset, in tender documents, in bids, that we do not tolerate any form of discrimination or harassment in the workplace.
Yeah, so there can be no sort of, oh, we didn't know, or forgetting to actually put it in your contract, because it's from the outset, whoever's doing that whole contractual process will pick that up as it flows through.
Yeah, and some of the NHS in particular, in their tenders, they've got to disclose any discrimination claims that they've had, and liability, any. So that's something that you can ask as well. Have you been subjected to any claims of harassment, discrimination in the past? And that's something that you could ask as well, which shows that you've done your due diligence when you're contracting with a third party.
And I was just thinking, because I'm just devising some training, but I'm just thinking for those, say for example, a CCG, a clinical commissioning group, who's wanting to look around and think, okay, what NHS organisation do I want to tender with? It could be any of three. They could potentially make their decision based on staff surveys, discrimination claims and things like that. Yeah.
Absolutely.
And the organisation may not necessarily know, so it's an additional reason to really put your house in order.
Yeah, absolutely.
Right. Thank you. Have we any other questions? I mean, are you guys prepared for this in your organisation?
How many, sort of just a poll, how many of you got policies in place at the moment if you're here on behalf of an employer or an organisation? Or does your employer have policies in place? One? Yeah. Oh, so a few of you do. Do you think they're adequate?
I'd say yes. I mean, as a coaching organisation, we have to have those policies in place so we ensure that our clients are safe.
Yeah.
So, yeah, I think they're adequate, but obviously we now need to, with what's going on, although we're a small company, we have to then look at how we review what we're doing and how,
yeah,
so it's in line with the changes that are coming.
Yeah, exactly. And I think, as I said, I think most organisations will have policies in place. I think it's training and monitoring those policies is going to be the issue, particularly for the smaller organisations. And I think, the legislation isn't in place at the moment, but it will be, because I don't think the government I think the government will proceed with it. So it's good to start thinking about it now, so that you're not rushing when it does come into place, so that you've got all your steps and everything in order now, and you've got time to put it in place before it does come in.
And I think, just to add, it just supports us in helping clients who come to us with these issues. So I really thank Dawn for bringing this webinar. So it's really getting me to think. Thank you.
Yeah, it's lots to think about.
Actually, Jane, you can thank Sejal because she's the one that suggested it. I just researched it. So it was Sejal.
A joint thank you to both of you. Much appreciated.
You're welcome. Juliana?
Yes, I just wanted to say that I think, because I work for an NHS trust, I think there isn't one NHS trust in the country that doesn't have an equal opportunities policy, doesn't have anti-discriminatory, technically, policies. I think the difficulty is, how do they implement it? And how do they make sure that they keep everyone that they need to keep safe? So I welcome this, but I'm not sure that people get it. Do you know what I mean? I think there's an issue that people don't really get it, and they think because they've got a line that includes discrimination for, they protect, all the protected characteristics are included in the policy. I don't think that's enough. I think we need to have a little bit more, and it'll be interesting to see how people respond to it going forward. No,
I agree. And I think I agree with you. I think every NHS trust does have a suite of policies dealing with equality, diversity, etc. It has mandatory training, which people have to do, which is sort of the tick box online stuff. But I just don't know whether that training is effective at all. And I think some individuals will just play lip service to it rather than take it seriously. And I think that in the NHS, I think that's the challenges.
And I think when Juliana was talking, so obviously it's about the policies, because we know that, people have policies, but they don't necessarily use their policies in the widest possible sense. But when Juliana was speaking and just thinking about the trust that she works for, I think there's thing about having a sexual harassment training and all the rest of it, but the idea of risk assessments entered my thinking, because certain areas will have a higher level of risk of sexual harassment than others. So as well as having the policies, the procedures, kind of like the touch points in terms of, surveys and the preventative and preempting, there are areas, and I can think of certain wards where actually it would behoove employers kind of like do risk assessment to address the level of risk in addition to all of those other things.
Yeah. I think John had a question.
Yeah, I've worked in large organisations for most of my career up until the last year, mainly in education. So have dealt with issues between university students and academics, and very much around what is and what is not acceptable. But again, in the last year, I've been doing some consulting, working with far smaller companies, and I have been amazed at the lack and the quality of policies, procedures and training in smaller companies.
Yeah.
And I think there's a as a piece of work around that, but also the culture of what is permissible. I've had 2 fairly heated debates with organisations around the lovely topic of banter. We are a fun office. We have banter, and people out there, particularly one very recently was in a sales environment, and I said in no way, shape or form can what's been said be seen as okay, whether you call it banter or whatever. They just saw it as it was laddish sales behaviour. And again, I think there's, and again, working within the NHS, I've done some work, worked in the NHS on and off for many years. And I've done some work recently with a very large trust around issues around sexuality and transgender, and how people are treated and harassed around those issues. And I think there's a big culture piece that policies, procedures, as people have said, can do wonderful things, but if you do something about the culture of the organisation, people pay lip service, people they go through their online training, ticking the boxes, and go back to their behaviour unchallenged. It is around culture of organisations, not just the policy.
And that's why I think online training, whilst it's there and it does the tick box, I don't think it's sufficient to prevent harassment in the workplace. I've had a similar heated debate with an organisation based in Liverpool about banter, and oh my goodness, wow, it was just, they just couldn't see it. And it was only when I said, you know what, if you carry on like this, you're going to be liable for what you're saying, and this is how much you could end up paying, and your employer won't support you, plus all the legal costs. That's when they went as white as a sheet, because they just didn't get it otherwise. And it's about protecting themselves. It's about protecting them as well in terms of what they're saying.
So in terms of individual liability, can you just talk to that point a bit more?
So basically, an employee who's been subjected to harassment can bring a claim against the individual who has made the remarks or subjected the perpetrator. And in the same way as bringing a claim against the employer, the claim would be against the individual. And the employer may fund it for the individual, but they may not. And if they don't, then they will be liable. They will have to meet the costs. If they want to instruct a lawyer, they would have to meet the costs for that. And any damages, they would have to personally pay. And they even may be liable for costs as well, because if a judge finds that they had subjected to somebody to harassment, and if it's pretty obscene and offensive, then a judge may well give costs against them as well. So
the employer, in certain circumstances, may decline to defend the employee.
Yeah, absolutely, and use the argument of reasonable steps and say, well, I'm sorry, we're not liable for his actions or her actions because we've got a policy, we trained, and he or she came to this training session and understood everything, and therefore, and we monitored the policy, but he or she still did it. So we're not liable. Why should we be liable?
But as long as the employer could demonstrate all of that.
Yeah, exactly.
Then the employee would be on a hook for potentially tens of thousands.
The employee could be, yeah.
Do you think that employers should make that clear in their training? Because I don't think that they do to date.
Yes, they should. And I do it all the time. That's the first thing I say in my first slides about personal liability, because I think that's really, really important for individuals to see.
The potential outcome of their actions.
Yeah.
Okay. Well, that's been an eye-opener for me, because it's been my experience that when people bring employee tribunal claims, they say the organisation is the respondents plus X, Y, and Z is the named individuals.
Yeah.
It's my experience that the employer will, make representations to get the individual employees off, and then defend the claim as an employer.
Yeah, the case that I referenced just a minute ago, Allay, that was a case where the employer said, we're not funding this defence for you.
So what happened with the employee?
So the employer lost the reasonable defence argument, and then therefore they were liable.
Ah, okay, okay.
Yeah.
But
Because the training was stale.
But you still have the angst, and I say this to people, that even if your employer does manage to get your name off, you still have that angst, you still have that stress between being named and actually being confirmed as that you personally do not have to defend that claim.
Yeah, but also I think you need to be aware that even if you're not named, not mentioning any of you because you're not going to be liable for anything like this, but even when a manager is not personally named in a tribunal proceeding, but the individual brings a claim of harassment against the employer because of the conduct of a manager, let's say, the manager may not be named, but the manager will still have to come and give evidence.
Yeah.
And if the tribunal makes findings against this manager, this is a public document for everyone to see. This could impact on the manager's ability to continue employment with this organisation, because the organisation will say, well, the tribunal's made these adverse findings against you, we're not employing you anymore. And then it could impact on the manager's ability to seek future employment.
So as a result of, and I read a case recently, and it was a religious discrimination case, and there were several points, if not at least 10, where the judgment listed where the claims of harassment, the different instances of harassment was upheld. So are you then saying potentially an employer could then read the outcome of that, the adverse findings against the managers, and institute disciplinary processes against that?
Yeah.
Okay.
Yeah.
And has that happened in your experience?
Yeah, I've been involved in a case where that's happened, and the employer dismissed the employee for a breakdown in trust and confidence because of the evidence that they gave in the tribunal proceedings.
Ah, okay. So not necessarily the actions leading up to.
Well, it both. Yeah.
No.
So it was both, because the actions leading up to it, the tribunal made a finding that actually those actions took place.
Okay. Thank you.
Yeah.
Thanks, Sejal. So we have 10 minutes. Does anyone else have any questions? Have any concerns about where their organisation is currently? Or do you think you're all tip-top?
I have to say, the issue about personal liability is really interesting, isn't it? Because you can imagine people will be, as John said, they'll be talking all kind of nonsense in a room, and everybody thinks it's banter. And then somebody said, no, that needs to stop. And still they go on because it's the culture. Could they argue that they weren't doing anything worse than anybody else in the team if the person accuses them as an individual?
Yeah, they could. Yeah, absolutely, they could. And I've had arguments that, why are you blaming me? Because it's banter. Even everyone does this in the workplace, and it's banter, but that doesn't absolve it, really, just because everyone else does it. So
no, I was just wondering if people could argue, because if your organization says, well, I'm not going to support you, it's going to hang on a minute, but it's everybody here does this. Why am I being not supported when actually you do it? And you're above me. The person hasn't accused you, and I learn it from you. Yeah.
So that's a defence or an argument that can be put forward, but that doesn't stop the liability.
Lord, no, it does not. Thank you for that.
Can I just say something? I mean, this is from past experience where I've noticed when issues like this come up, and whether it's race or sex, whatever, that some employers would actually request that the perpetrator leave. Where does that leave the victim in terms of them taking action?
They can still bring a claim.
So often.
They can still bring a claim against the perpetrator. Just because they've left the employment, they can still bring a claim against them. And this only applies in discrimination claims only, and harassment claims, the personal liability bit. So it doesn't apply if an individual's been dismissed. They can't bring a claim personally against the manager that's dismissed them. This only applies in discrimination claims.
So in the instance that someone has left the employ, okay, someone brings a claim, who would be responsible for defending that claim?
The individual.
Even though their actions were taken, you know, they conducted themselves whilst employed.
Yeah, the individual would be.
So it would shift to the individual. Would the employer have any liability?
So it depends on who the employee brings a claim against. If the employee brings a claim against the individual only,
Yeah.
it'd be the individual that defends it.
Yeah.
If the employee brings a claim against the employer defends it. If the employee brings a claim against the individual and the employer, they both defend it.
Okay. Okay. But there is still, even in the instance where it's an employer and the employee could potentially still be responsible for the financial burden, part of the financial burden.
Yeah.
Okay. I have learned something today.
Thank
you. Thanks for your comments. So I've got some really positive comments here. Thank you very much for this very interesting, super interesting. Thank you so much for the eye-opening explanation, and it employs, especially around liability. Yeah, and so before we go, because literally the floor is really open to you to ask questions, any concerns that you may have, maybe if you need help with a particular area. Otherwise, you are free to go.
Just wanted to say thank you so much. I mean, your questions were amazing, and thank you for listening. Really appreciate it.
And likewise, thank you for attending, and thank you to Sejal, sorry, and I will post a link.
Yeah. Dawn, just so that you know that Sarah, my head of marketing, sent you the link to the briefing. So maybe you can post that when you send out the.
I will. Yeah, I'll do both.
Yeah.
All right. Thank you.
Perfect. All right. Thanks, everyone.
Brilliant. Thank you.